exactly what happened was that Ashgold Sporting Club filed an injunction to restrain the playing of the Bet Power Premier League for the 2022-2023 season, and the GFA actually responded to the motion for the interlocutory injunction. After they have responded, they raised issues which we addressed in another court process, usually called the supplementary affidavit, in support of Ashgold's application for injunction. So in the courtroom today, after announcing ourselves, and when counsel for the Ashgold, that is myself, got ready to move the motion for the order to restrain the GFA from proceeding to play the Bet Power Premier League, lawyer for the GFA, my learned friend, raised a preliminary objection to the filing of the supplementary affidavit of Ashgold. And so she actually made an argument to the court that the supplementary affidavit Ashgold filed in support of the order for the interlocutory injunction should have been filed with leave of the court. And the truth of the matter is that when Ashgold was responding, they failed to respond by bringing the leave, all right, before filing the supplementary. Then the court actually listened to her arguments, and we were asked to respond. And we also responded by letting the court know that there is an irregularity with her raising of the preliminary legal objection to our supplementary affidavit. What is the irregularity? So we argued in court that any objector to any court process, okay, by way of what we call preliminary legal objection, ought first to give notice to the other party. Secondly, must give reasons, okay, to the objection. And then thirdly, such notice ought to be given to the other party at least 3 days before the hearing of the motion. And so we argued that her failure to bring us notice, all right, of her preliminary legal objection to our supplementary affidavit by itself is irregular, and the court ought not to listen or countenance her preliminary legal objection. After that, the court gave its ruling, and the court ruled that indeed Ashgold ought to have come to court for leave before filing the supplementary affidavit, and their failure to do so renders that process irregular, and same was struck out or set aside. Now, the court further also ruled that the preliminary legal objection counsel for GFA also raised is also irregular, to the extent that she also failed to give to Ashgold or counsel for the Ashgold notice of the preliminary legal objection and the reasons why, she's raising that. And for that matter, the preliminary objection was declared irregular, and the supplementary affidavit in support of the motion for injunction was also rendered irregular by the court. Then we are of the considered opinion and brought to the court's attention that the facts or the content of the supplementary affidavit are germane, to our case, and it provides material facts that this court ought to look at, and to ensure substantive justice, over what we call procedural law, we urged the court to grant us the opportunity to come properly with the leave to file the supplementary affidavit in support of the motion for interlocutory injunction. A counsel for GFA forcefully opposed that prayer, saying that the GFA is losing at this moment, and for that matter, the court ought not to grant us that leave to file the supplementary affidavit. But eventually, the court ordered that by 17th October, which I believe is coming Monday, we should have filed the motion for leave to file our supplementary affidavit, and then also return back to court on the 20th of October, which is coming Thursday, to move the said motion for the leave to file our supplementary affidavit, and then the case will take its normal course. So hopefully next week, Thursday, if the court is satisfied that leave should be granted, then the court would grant us that leave, and we will go and file the supplementary pursuant to the leave, serve lawyers for GFA, and then they also have a right to respond to the content if they so wish, after which we come back to the court and now deal with the motion for interlocutory injunction itself, and the court would have to exercise its discretion one way or the other in a grant or a refusal, and that will bring that aspect of the case to an end. But the substantive case will continue till it is determined on its merits as expected in the judicial system.